John's child support almost doubled without him even realizing it. The way he found out is he woke up one morning, checked his bank account, expecting to see a deposit for $1,350 for payroll, and instead it was only $800. He had been paying $650 a month in child support for 3 kids for the last 6 years. Well, child support office wanted to increase that. They thought he was making more money. So they filed a motion with the court to increase his child support and sent a copy to his last known address. Problem is, John had moved and hadn't given them his new address. When it got to court, child support said, we mailed him a copy. Judge said, okay, he's not here. So what the judge did is increased his income by 10% each year, which the statute allows. That increased his income for child support purposes substantially, which in turn increased his child support from $650 to $1,200 a month. John could have avoided all this if he had only given child support office his new address when he moved. A number of years ago, I had a client that fell into what I call the child support black hole. What that is where a father will get behind on his child support. In this case, the father owed about $600 a month in child support for 3 kids from 2 different women. That was his ongoing child support. Well, he began to fall behind because he would lose jobs. He would get jobs that paid cash and he wouldn't pay the money to child support. He even did a little stint in jail for DUI. Well, when the grim reaper of child support finally showed up at his doorstep, he owed about $40,000 in child support, back child support, arrears. There's no way he was ever going to be able to pay that. Well, what the child support office did was every time he would get a job making money at a factory or a company, they would issue a wage assignment. And with that wage assignment, they would take about 50% of his earnings. So if he was getting paid $12 an hour, child support would take $6 of that $12. And after taxes, that would leave him about $3 or $4 an hour to live on. And that's not enough to live on. His incentive to make money and to pay child support was completely shot. It was gone. His incentive to be a father was gone because he couldn't provide for his kids. So he rarely saw his kids. He wasn't really a father to them. What he ended up doing was dropping out of society. He got menial jobs, making cash money. If he did get a job at a factory or someplace that would report his income and his employment and a wage assignment issued, he'd quit and go work somewhere else because he couldn't handle only getting $3 or $4 an hour. I don't know what the answer is in that case, but when he hits 80 years old, if he's still alive, he's going to owe tens of thousands of dollars in child support. What I mean by that is he'll never get it paid off. What do you think the solution is to that? If there is a solution, and there may not be. And I believe that all parents should financially support their children if they're able. But when you put somebody in that big of a detriment as it relates to child support, they're going to lose all incentive to be a father, to be a provider for their kids. What do you think the solution is? You got any ideas? Up until a couple of years ago, if you were sentenced to jail and actually went to jail and you had a child support obligation, that child support didn't stop while you were in jail. The reason why was simple. Whatever you did to put yourself in jail, you did voluntarily, whether it was using drugs, selling drugs, whatever, you did it voluntarily to put yourself in jail. Why should your kids suffer? So it was considered voluntary underemployment when you went to jail, and your child support didn't stop. So guys that were sentenced to 2 years in jail that owed $600 a month in child support, when they got out, they had a $12,000 arrearage. Well, that law changed a couple of years ago. The federal government actually amended the statute that sets up the child support system to say that states can no longer consider incarceration as voluntary underemployment. What do you think about that? You think guys sentenced to jail or girls sentenced to jail should have to continue to have their child support mount up, or do you think it should stop? Did you know that just because you file for divorce doesn't mean you have to follow through with it? There are a couple of ways to stop a divorce. The first and probably the most common way is just simply to dismiss it. To go into court and say, hey, we no longer want to pursue this divorce. We're dismissing it. Still got to pay the court costs, but you can dismiss it outright. The other way is something called an order of reconciliation. Most states have it. Tennessee has it. In Tennessee, you can get the judge to sign an order of reconciliation, basically saying the parties are trying to reconcile. What the court does is sign that order. The court file is literally put on the sidelines, sits there for up to 6 months, And if you're able to reconcile, the court will dismiss the divorce case. If you're not, it comes back up on the docket. The advantage to an order of reconciliation is you don't have to refile the case if the reconciliation doesn't work out. All courts encourage parties to stay married if they can. This is a little lesson in child support that, although boring, will hopefully help those of you paying and receiving child support to have a little better understanding of, well, how and why child support is what it is. First off, where does the concept of child support come from? Well, without going through the entire history of child support, suffice it to say that federal law requires states to set up child support systems. Specifically, Title 4D of the Social Security Act requires that states establish guidelines, each state establish guidelines for setting and modifying child support amounts in each state. So that essentially means that every single state in the United States is going to have a child support system in place and have laws in the form of child support guidelines for calculating child support. Now, pursuant to these federal laws and regulations, the child support guidelines that are established by each state must, at a minimum, be applied in all the courts, administrative agency, or by other officials in a state who have the power to determine child support orders in that particular state. And it basically means that your child support in a particular state should be the same no matter who's making that determination, a judge, an administrative agency, whoever. But this does not mean, and this is important, that your state law will be the same as another state's law. So although child support awards are going to be the same no matter what court or agency in your state makes that child support determination, it doesn't mean your child support is going to be the same in different states. So it may be different in California than in Tennessee. Now, each state's guidelines have to provide that the child support order is based on the alternate residential parent or non-custodial parent's earnings, income, or any other evidence of the ability to pay that takes into account all earnings and income of that parent. It's got to be based on specific criteria that normal people can understand, and it's got to result in basically the computation of a dollar amount for child support. It's got to address how the parents are going to provide for a child's health care needs through either public or private health care or through cash medical support. And finally, and this is a new one, it's got to provide that incarceration may not be treated as voluntary unemployment in establishing or modifying child support orders. Now, if a state refuses to apply this federal law in creating a child support system, that state's going to lose out on a tremendous amount of federal money. That's why we have the child support system that we have in this country.